Yeah.
Contracts and Monty Python, so
I'm
maybe.
sorry?
My weekend consisted of contracts and Monty Python, so I would guess so.
Okay.
Hey.
At least half of that was well spent. And I'm not going to say which one.
Definitely the Monty Python.
Yeah.
I hope a couple of things. Well, first, I have your box of assignments with me. All the teams got credit. Did well. Few slip-ups, of course. I didn't expect anything other than that. It's inevitable. What I did was there were some teams that I thought did a really, really excellent job. And those teams, I think there were 7 of the 20-some teams, something like that. I gave them, the members of those teams, double credit for class participation. And you will see when I give you them back at the end of class, if you got double credit, your sheet is marked with an asterisk on the last page. So you'll know that you got double class participation credit for yours. Then there was one team that did the best job of all. And I haven't decided exactly what their prize is going to be in addition to the double participation credit, but I did want to recognize how well they did. Pretty much perfect, with really good explanations. And that was Ms. Fields, Ms. McCarg, and Mr. Williams. Well done. And they're all thinking, oh my God, I can't believe it. But you all did well. I mean, and there's some things that probably some of you, when you see my comment, you'll be like, well, I thought I had that. I'm not sure I understand it. Come see me. You're not sure you understand my comments and why I said X when you said Y, or I said your explanation wasn't clear enough, or whatever I said. If it doesn't click with you, come see me, because that's how you'll get the value out of doing this assignment. Okay? Second, I hope quite a few of you are able to come tonight to the panel on criminal justice reform. I think it's a hugely important issue in the area of criminal law. The Kentucky General Assembly is working on this issue, had a bill before it last term, at least one, during the last session, and it's going to come up again. That bill did not pass, but it's going to come up again. The moderator is one of the, for tonight, is one of the sponsors of legislation for criminal justice reform to deal with the problems of over-criminalization, mass incarceration, inconsistencies in the criminal law, all of those things. And the panel is top shelf, really interesting. It even got me to dress up, and I don't dress up, as you have seen throughout the semester. The other thing to know about this whole initiative is that it was sort of the foundation for it, or the approach for doing this was made by an organization called the Justice Action Network, which is sort of a fusion group of conservative activists and scholars and others who are in favor of criminal justice reform and progressive. So it's sort of left and right coming together. And the Justice Action Network is working with the dean and Professor Milligan and I to put together a fellowship in criminal justice reform here at the law school, which will involve some money for students to do work, research, and other things, putting on programs, a whole set of cluster of responsibilities. So if you are interested in this issue and might think of yourself as somebody for whom this fellowship, again, once it gets off the ground and still in the planning stages, for whom this fellowship might be a really nice possibility, I think attending tonight would be a great way to sort of get yourself involved. Okay? All right, so that's all I've got by way of announcements. Anything on your minds? Yeah.
So I read an article. It was titled, "Our brains are wired to search for a problem."
I'm sorry, what was that again?
Your brain is wired to search for problems to fix.
Okay.
And so, the article was saying that as an event or a phenomenon becomes more rare, we're actually going to look for it more.
Okay.
And to me, that has a lot of implications in criminal law, because as police officers, as judges, and as juries, crime decline, but then we saw incarceration increase.
Right.
So I could see where that concept called concept creep could be playing a factor in increased incarceration rates despite crime declining. So that was just interesting to me to think about, you know, as people in this field, that despite, like, if crime is declining, but we're still looking for that, you know, suspicious behavior and deeming something suspicious just because, you know, our brains are looking for it, that's something definitely to keep in mind.
Yeah, I think that's really interesting, and I'd love to see that article, by the way. And I guess it depends on which you think comes first, the chicken or the egg. And by that I mean, at the individual level, as you say, something becomes rarer, or we look for the problem, we seem to see it more, it becomes more noticeable to us because it's rarer. So at the individual level, if crime is less prevalent, we see it more, it becomes more of a concern, and that then puts the pressure on the political system to respond to greater concern, even though there's lesser crime. And the response of the political system is, oh, let's pass harsher sentences. Let's criminalize behavior that wasn't criminal before. Let's eliminate parole, mandatory minimums, et cetera, et cetera, et cetera. All the things that produce mass incarceration. So that's if you think the chicken came first. But if you think the egg came first, and that it wasn't the pressure from individual people responding in the way you're suggesting, but it was a purposeful manipulation by those in the political system for political gain to sort of stir up anxiety, to take advantage of concerns about crime even though crime rates were declining. That's sort of a more cynical view of the egg came first, and that then whipped up frenzy over crime, fears over crime. So you'd have political gains made by those who felt that they would benefit politically from it. So, or it could be some combination of both. So I think a further sort of teasing out of it might ask the question, what was the real original source of the impetus for some of these statutes, as you say, even in the face of declining crimes? That'd be the way I would want to think about it. Anything else? Okay, we had left off with MTS, what does New Jersey law say in its definition of second-degree sexual assault? And while I normally take volunteers, for this particular case, or at least on one side of it, I am going straight to Mr. Webb. Because Mr. Webb, you said earlier in the semester, if I recall correctly, you can disabuse me of this if I'm wrong, that you were going to be our resident textualist, right? Do I remember that correctly?
Regrettably, yes.
What was that? Oh, regrettably, yes. Well, that means I have to call upon you here. I have to call upon you here. So what does the New Jersey law say constitutes, is the definition of, are the elements, if you like, of second-degree sexual assault? I'm stalling here to give you a little more time.
Thank you. You still like calling on someone else?
That would be stalling a little more than I'm inclined to at this point. All I need is the statutory definition for now.
Is that on 958?
I'm sorry?
Is that on 958?
I think it's on 956, actually. It's also on 958 in the footnote in the book.
Okay, it says that sexual assault is the commission of sexual penetration with another person, use of physical force or coercion.
An act of sexual, so it's an act of sexual penetration. Using physical force. As our resident textualist, what would be your argument for how this, what is the relationship in this statute between sexual penetration and force?
That's repetitive almost.
I'm sorry? It's repetitive? Well, legislatures get to be repetitive. They can even be irrational at times. They can be political all the time. But we have to try to make sense of what they wrote if we're going to be good textualists. So what does this mean? What would you say this means about these two things, if they are two things, sexual penetration and force?
It's separated into two elements if you're going straight textualist.
What would
It's separated into two elements.
They're two different elements, and in fact, you do this by means of this, right? By means of this. You use physical force to accomplish, to bring about sexual penetration. So a textualist would seem to say the act that constitutes force, whether it be a threat perhaps, or whether it be putting a gun to someone's head, whether it be holding someone down, etc., whatever it is, the act that constitutes force is not the sexual penetration itself. Because this is how this happens. It's not the same. Okay? And this is a pretty strong textualist argument. Whose argument is it in this case? Who argues this as the basic approach to why or to how this case should come out? Who makes this argument? I'm sorry? The defendant. Right? This is the defendant's argument in this case. Look, all that the prosecution was able to show by way of by physical force, so this is the defendant's argument, all prosecution could allege as an act of force was the act of sexual penetration itself, and that is not enough or contrary to the requirements of the statute. And that is not a bad argument, depending on how we're going to interpret the statute, right? And one of the things I want us to think about that this case sort of brings to the surface, brings out, is how do we want to interpret statutes? Because as we'll see, the New Jersey Supreme Court is going to have none of this argument. And in having none of this argument, in rejecting this argument, they sort of reject, although they don't quite say it in these words, they reject the whole approach to taking this very strict textualist view of the statute. And you might argue, putting aside what you think of this case, that's a dangerous thing for courts to do, to rewrite statutes in a way that is not suggested by their actual language. You might think, or you might not, but you might think, okay, that's a good result in this case, but I'm still concerned about the courts doing that. Because in other cases, they might do that and reach bad results. But I do want to keep in mind that as we go through this case, think through what your views are of how the court went about reaching the result it did. And now we'll talk about that. Okay? Because the issue is, can the penetration that is involved, that is shown by the prosecution, constitutes the required physical force in and of itself or by itself? Okay? Here, the defendant, there is no question, MTS, had engaged in non-consensual sexual intercourse with the complainant. Okay? They offer very different accounts about the events leading up to his actions. He says there was consensual mutual kissing and fondling. She says he surprised her in her sleep. We're going to see that issue again as we go through the day. And she said she responded by slapping him in the face, told him to get off of her. The trial court said, well, I think it's somewhere in between. The truth is somewhere in between. The victim consented to a session of heavy petting, of kissing, and she hadn't been sleeping at the time of penetration, but that she had not consented to the sexual act of intercourse. So that made it non-consensual. But the appellate division said, no, we cannot convict under these circumstances, as the intermediate appellate court, because the absence of force beyond that involved in the act of sexual penetration, or the absence of force, precludes a finding of second-degree sexual assault. Okay? So how does the New Jersey Supreme Court resolve this argument about whether an additional act of force is required? Crickets. How does the New Jersey, we know the appellate division said no, and we have to reverse the conviction because an additional act of force is required. What does the New Jersey Supreme Court say about that, Mr. Williams?
Well, their reasoning goes to the changing definitions of the sexual assault crime and how the legislature has changed it to look more like the other forms of assault and battery.
So one thing they say is they relate the sexual assault definition to the general law of assault. And what's that how does that comparison work, and what conclusion does it yield?
When you place the emphasis on the kind of the assaultive nature of the crime, it's part of what
does the court say about general law of assault that it finds relevant to resolving the issue?
They talk about it as a general rule. Criminal battery is defined as the unlawful application of force to the person of another.
Unlawful touching can constitute an assault or a battery. And why is that relevant?
Because it helps to take the victim sort of off of being on trial themselves. And
that's another point. I want to talk about that. We'll put the number 2 for that in a minute. Stay focused here on this argument. What is the relevance of this observation about the general law of assault? Why is it relevant, or how does the court use it to draw conclusions about how to interpret sexual assault specifically?
Because of the lack of consent, and that with regular assault, there's not an assumption of consent.
I don't want to get to consent here. I want to stay focused on this idea of a touching.
So it could be any kind of offensive touching. It doesn't have to lead injury to the person. So
if you only need an unlawful touching, what idea does that support? What conclusion could that be said to support?
There doesn't have to be resistance.
I'm sorry?
There doesn't have to be necessarily resistance to the...
Hit me with that. A little louder.
Resistance. There doesn't have to be resistance.
Any amount of touching would satisfy the element of physical force.
The idea is here, look, any touching, and that should shouldn't require extra, shouldn't require more than one thing, should require for any assault, any touching, and by the way, that could include, or should be able to include, sexual penetration. This kind of analysis, this kind of interpretation, I would sort of get, urge you to identify as structural. The court is saying, look at one provision, the provision that happens to be before us, within the overall structure of the law. Sort of, it's a part of the departure from textualism, saying we should understand this statute within this overall structure of the general law of assault. And within that structure, the idea is that any unlawful touching constitutes assault. The penetration here, again, if it's non-consensual, is such an unlawful touching. No more should be required if we're going to keep this provision consistent with the overall structure of the law of assault. So one approach you can use to building an argument here that the New Jersey Supreme Court uses is to see a law within its overall framework. One provision within the overall framework of the law as a means to understanding what it means, what the legislature meant, how broad it should be, etc. Okay, so this is sort of a structural approach to statutory interpretation. All right. Mr. Williams, you wanted to talk about what was the second issue you brought up?
It serves to take the focus off the victim, make it so it's not like they're on trial.
So within a different framing, this was about the framing of the law of assault and sexual assault as part and parcel of that. This is, the framing is, let's see this change in the law, this definition of the law of sexual assault within the framing of the evolution of rape laws. And the court goes through an extended discussion about the evolution of this law, the law of rape, to, for example, take the focus off the victim, conduct, resistance, etc. So the court is saying, if we're going, we should interpret the statute in line with the broader movement of which it's part. And that means having not a special requirement of force, because remember we talked about how we're going to eliminate, we might eliminate the resistance requirement. Now we're going to go further and eliminate the independent requirement of force and put all of the focus. Now, I think this is there's a little bit of internal tension here, because we're going to put all the focus on consent or lack thereof. Once it's shown to be non-consensual, we'll talk about what the court says on that score. Once it's shown to be non-consensual, that's all you need. The problem with that, arguably, is it does put the focus back on the victim's mental state. Did she consent? But the idea is we're going to take it off of some requirement of how she had to behave. Okay? If sexual penetration is enough to constitute the force, that seems to open the door, unless we add something else back in, to allowing any act of sexual intercourse to constitute rape. What is only second-degree sexual assault? What does the court say here is still necessary for sexual penetration to constitute second-degree sexual assault? Obviously, it's not enough to have penetration be enough. Got to be something else. What does the court say?
Affirmative and freely given permission.
The defendant applies any amount of force against another person in the absence, add a little bit more, in the absence of, you said freely given permission, but there's something before that.
Affirmative and freely given.
But even before that, same sentence you're on, there's a key step in there.
Sufficient.
What a reasonable person would believe. So it's penetration in the absence of what a reasonable person, there's our friend, the old reasonable person again, would believe to be affirmative consent freely given affirmative consent. Okay? What does that mean? What instructions would you give the jury, for example? If I gave you a question and you saw that it involved sexual assault with a statute similar to New Jersey, and I asked you to give instructions, write an instruction to the jury that the judge should give on this issue. What should the instructions say the jury should look for?
That if the defendant reasonably believed that they had consent, then they should not be found guilty.
If the defendant reasonably believed that they had consent. Is there anything else that goes in there? I'm sorry?
Affirmative and freely given.
Affirmative, and how do those play in?
Non-coercive.
So the consent cannot have been the product of any coercive force or threats made by the defendant. What about the affirmative part? Madam Prosecutor, how are you going to argue to the jury as the prosecution that affirmative should be implemented? How should they look at that word affirmative consent? Affirmative permission.
That, so wait, the prosecutor or
As the prosecutor, I'm just me.
oh, okay. So that, the affirmative consent was implied through.
Affirmative consent was implied, and now my head explodes. My head explodes because I don't know what that means, or even if that's possible. What is the prosecution going to say is required for affirmative consent when it comes to the issue of implied versus explicit?
That to make it affirmative consent, the person would have to explicitly say yes.
So it can't be enough that you just relied on what you thought were signals, right? What's the defense going to say about affirmative consent, Ms. Call?
That it can be inferred from the victim's acts or conduct based on all the surrounding circumstances.
That it has to be affirmative, right? But actions that a reasonable person would construe as consent, because that reasonable person is still in that definition, can require consideration of implicit indicators, implicit behaviors that show consent. And this is a huge issue in the law of rape and sexual assault, as all of you, I'm sure, know, right? The issue of, is it required that you obtain affirmative consent, and must it be explicit? And there are widely divergent opinions and widely different statutes across the country. On campuses have student conduct codes that have different rules on this. And so this is our first encounter with this idea, and the New Jersey definition here, as the Supreme Court puts it forth, it allows both sides to argue this question about, must there be explicit consent? Must you say, are you okay with this? Do you want this? And then the answer must come explicitly, yes, let's have intercourse, right? Could a reasonable person reasonably believe that there was consent in the absence of an explicit statement? That's an argument. There is no clear answer to this. Our law is still wrestling with these questions. And you may have the chance to influence the development of the law, right? As legislators, as litigators, doing criminal law, doing work on rape and sexual assault. where we end up, if the law ever ends up in one particular place, will depend on how legislatures respond, how cases are decided, etc. Okay? Any other questions about MTS? A great case to sort of bring out issues of how to interpret statutes, where the law is along this spectrum of the law, the reform of rape statutes. Lots going on in this case. Okay? All right, let's talk about Mormon. What happened in August of 1984 to the complaint?
So the victim in this case, the incident happened 3 years before this, like came before the Supreme Court of North Carolina, and the plaintiff was sent home after being out of her sentence until 1 hour.
Okay.
She fell asleep fully clothed and like returned to her dorm, turned on the radio, like before she went to bed, and then when she woke up, she realized that she said she had a dream she was engaging in sexual intercourse, and then woke up and found that someone, the defendant on top of her, having intercourse with her, and she tried to sit up and push the defendant off, then he just pushed her back down, and then...
So under the New Jersey rule, for example, there would be no issue, presumably, it's not the legal issue in this particular case, but just to sort of bring it out, there would be no issue about whether they were separate, independent acts of force and penetration, because the pushing her down could be this separate act of physical force. So even if the New Jersey Supreme Court had gone the other way and said, well, there has to be force separate from penetration, we would have that here. Okay, everyone see that? All right, so then what happens?
So then she didn't resist anymore because she was afraid that she'd be injured by the defendant. And then he continued to have intercourse with her. So then whenever the event was over, she went and turned on the light of the dorm. And the defendant said that he thought she was Lynn, which was her roommate at the time. And then he told her not to contact the police and said that he wouldn't have done this if he knew it was her, not Lynn. He said, like, in the dark, he couldn't tell who she was.
All right. That's the first place I want to pause for a minute, because remember, at various points during the semester, I tried to bring out specific facts and talk about how you would argue or use that fact on one side or the other. Here's where I want to do one of those. He says, according to this, at least this testimony, that he wouldn't have done this if he'd known it was her, but presumably he did do it and was willing to do it when it was Lynn. What do you say to the jury about that in this process?
I would say that if someone's asleep, no matter like if you know the person or not, you should not go and try to have.
Just you should not, like he's being
wrong.
bad.
It's
wrong. So it's just morally wrong.
It's illegal.
Right. You're going to say, sort of in an incredulous way, I think. Wait a minute. Is he telling you that if it had been Lynn, it would have been okay? That shows that his mental state was to have non-consensual sex, because even if it had been Lynn by definition, as he perceived it to be, would have been not capable of consenting because she was what? Asleep. Right? I mean, it's kind of mind-boggling that the defense thinks this gets them anywhere. So tell me a little more about how the defense, what Mormon has to say for himself.
Well, he testified and he said that he, in the room, he called out, like, before he went onto the bed, he called out Lynn's name, but got no response.
He got no response, right? So if you walked into a room and saw someone laying down on the bed and got no response, what would your assumption be?
Probably not them.
I'm sorry?
Probably not them.
Or
you check and see
Or more just generally. I'm sorry? They're asleep. Right? There's a good reason that the reason they didn't respond is, hey, they're asleep, so they didn't hear you. And if I'm the prosecution, I make that point by the defendant's own testimony. He testified that he came into the room, called out Lynn's name, and got no response. The most natural assumption, ladies and gentlemen of the jury, and you do not need to leave your common sense at the door when you go deliberate, is that his perception must have been that whoever it was asleep. Right? It's the natural conclusion to draw when somebody laying in bed does not respond to you calling in some way. Now, even if it was the complainant and not Lynn, then the complainant, if she'd been awake, would have said, she's not here, or no, I'm not Lynn. Right? It's not a natural assumption in any plausible way to conclude anything other than that whoever it was, she was asleep, and the defendant should have understood that from these circumstances that we have so far. Okay? So, Ms. Ramaswamy, if you walk into a room and you find somebody asleep, let's say you thought you had permission to enter in the first place, so there's no problem with his entry into the room, and you get no response, is your natural next step to go ahead and kiss that person on the back of the neck?
Probably the
Is anyone's natural next response to say, okay, I'm good to go. I can kiss that person. I can make physical contact with a sleeping human being? I see no hands. I'm going to take that as a no. But that's what he does, right? He kisses the complainant on the neck. Then what happens?
He assisted her in
I'm sorry?
her. This is in his testimony.
Yeah.
He claimed he kissed her on the neck, turned her over, and invited him, the girl turned over, and then invited him to engage in oral sex.
And this is the point where, if it's not enough, what we've already talked about in terms of the prosecution's case being made for it, here's where it is. According to his testimony, he kissed her on the neck, she turns over, and she invites him to engage in oral sex. What's the problem now with his defense? Think about how these facts fit together. What's the problem with his defense, Ms. Carnes?
See her face now?
And
She is.
not only seen her face, but
Hear her voice.
Well,
Hear her voice.
he's heard her voice.
Yeah.
And yet he still claims what?
He doesn't know.
That he thought it was Lynn. Because he says later, I didn't know until after we'd engaged in all these sexual acts, I didn't know it wasn't Lynn until then. And I was so surprised. So he hears her voice, he sees her face, he engages in all these sexual acts with her, and doesn't know that it's the roommate. So he says. On a scale of 0 to 100, how plausible is this story?
-50.
It's crazy talk. It's crazy talk. And yet, the defendant is running with it. So it should be no surprise that what happens in terms of the outcome of the trial court.
they convicted him.
He's convicted, right? It's like, this story is so implausible, so unfathomable, that it naturally results in conviction.
I'm curious to know, when it was dark in the room, because I know she was sleeping and the radio was still on, and maybe you didn't see her face that well, and maybe you wouldn't have been able to know because that well, the radio was still on. Just
Ms. Morton is not my favorite student. And Ms. Morton has the soul, or at least is pretending she has the soul of a defense lawyer. And I love that, right? The idea here is, let me build a narrative from facts, and maybe we have to see what those facts could be. It was dark. The music was still playing, such that he could have somehow still believed it was Lynn. Ladies and gentlemen of the jury, and if I'm a defense lawyer, I'm going to go with that in a way that sort of acknowledges how difficult it seems to believe at first. Ladies and gentlemen of the jury, the prosecution would have you believe that it was completely beyond the pale to even speculate or believe that my client could have made the mistake that we're telling you he made. But it wasn't that implausible. It was dark in that room. The music was playing, and so it was harder to distinguish one voice from another. It wasn't that, and maybe they looked somewhat alike.
Maybe
Right?
they just met.
Well, it sounds like Lynn was a friend. So I don't think the just met part, but sure. Anything you can build to try to, and then you have to say, and remember that prosecution has the burden of proof beyond a reasonable doubt. Okay? For me, I ain't buying it, and we know the jury didn't buy it. Because, remember, that if I'm the prosecution, I'm going to say they were close enough to be having intimate contact. There was, if he'd been across the room, then okay, maybe he could have mistaken a voice or a face in the relative darkness. But close enough that he was kissing her on the neck, that's just not. That stretches the imagination just too far, is the way I would argue it. And we know who won at trial. So we know what the jury thought on the facts.
In some relationships, like obviously if you're a married couple or in some dating relationships, it's completely acceptable for either one to wake somebody up by giving them a kiss or a hug or something like that. So if you could establish that was the relationship you had with Lynn, and then not fight the I didn't know who this was bit, but say at the moment that she turned over and she invited whatever, he didn't care that it wasn't her and reasonably understood that this person wanted it. Now, I would not ever defend this person, but if you went with that kind of argument, like how can anybody prove otherwise?
Well, let's assume that yes, his relationship with Lynn was such that it would have been that they had sort of established consent by prior behavior that they could wake each other up with a kiss. And you're suggesting, I take it, that he decided once he realized it wasn't her, that he didn't care that it wasn't her, he was gonna have sex with her anyway.
Well,
First of all, if I'm Lynn, I want to know that.
That he didn't care and thought that it was okay if he said she invited it.
That he,
Which I
well,
don't believe,
but I
but-
want to focus on the first part. Because if I'm the prosecution, I'm going to use that. It may not be kosher, it may not be technically relevant to the legal issues, but I'm sure going to use that the defense is saying that once he realized it wasn't Lynn, or that that's an implication of the defense's case, and he just didn't care. He was going to have sex with whomever. Yes, as long as it was consensual. And then I'm going to attack the consensual part in a minute. But because he's going to look like a heel. And I want the jury to see him as a heel if I'm the prosecution, who's, based. And I suspect that if that story comes out, Lynn's not going to be particularly enthusiastic about testifying for him to say, oh, it would have been okay if it had been me. The other problem with that whole theory is that the complainant had been sleeping. And the question is, can you be giving consent? The jury certainly will have to resolve and decide one way or another whether the complainant actually gave consent, and they obviously decided she hadn't. You prove it by her being credible, by his story being not credible, by him being a creep, and worse. I mean, juries make those determinations all the time. So he gets convicted, but what happens when he gets convicted, when it goes up to the intermediate appellate court?
They reverse the trial.
Well, wait a minute, why? We might be able to construct a defense for the jury, but once the jury rejects it, he should be toast, right? Why does the intermediate appellate court say not so fast?
So they're looking at a statute, a North Carolina statute, I don't know what GS stands for, but the statute
Usually
has,
it means general statutes.
has 2 theories of second-degree rape.
Two provisions. two definitions, and either one of which can constitute the crime. What are those two definitions, and how do they differ?
So the first one was that vaginal intercourse was committed by force and against the victim.
By force, or?
That's the one for the victim.
Okay, that's the first one.
Oh, and then the second one was that intercourse was committed, like, it could be second-degree rape if it's committed against someone who is mentally defective, mentally incapacitated, or physically helpless.
Lacks the capacity, basically, to consent on one of these grounds, including, of relevance to us, physically helpless. So these are two different definitions, the intermediate appellate court says, and what was wrong with the prosecution's case?
They said that the prosecution proceeded on the first theory.
That the indictment was by force or threat, right? But that the proof was
Needed to go by the second theory since the victim was asleep.
right. So they're saying, look, the proof conformed to the second one, but they didn't charge him with the second one, helplessness and incapacity to consent. So the proof didn't conform to the indictment, and so the prosecution loses. You're going to charge under one, you got to prove under that one. You're going to charge under the other, you got to prove under that one. Okay? So what does the state Supreme Court say about this?
They said that it wasn't required that you had to proceed under either of those theories, given that the evidence supports a conviction of rape on a theory of force and lack of consent, and there was no fatal. They said there was no fatal variance between the crime and rape.
The court, exactly. The court says, look, this case certainly could have been brought under A2. Okay, could have been a physically helpless case, but the state established the proof it had, also established that Mormon had intercourse with a sleeping victim and who was incapable of giving consent, and these facts also satisfy the elements of force and non-consent. So the facts elucidated at trial, the facts that the prosecution put forward, can be either one, and that means there was conformity, not a fatal variance, as the state Supreme Court puts it, with the statute. Okay? Now this may seem like it makes the statute redundant. A1 and A2 are now redundant of each other, but only in certain kinds of cases. Only in cases where the person is both, say, physically helpless or incapable of consent, and the prosecution can also show force or a threat of force. And then in those cases, the prosecution can go under either theory. But there'll be some cases in which the person's not physically helpless, is not incapable of consenting, just didn't consent, then you have to go under A1. Or it might be a situation where no force was used, the person was just incapable of consenting because of a mental condition, because they were asleep, but no other force was used. And then you have to go under A2. But in those cases in which the Venn diagrams overlap, because all those elements are met, you can go under either A1 or A2. Okay, everyone see that? So that they're not going to be always redundant in every case and make the statute make one section or the other meaningless. Questions about this? Yeah.
So the jury was presented with the second element of the statute, and were they told you could convict under one?
I don't know what the instructions were, but if you're going to use that theory where the indictment is under A1, and then the jury would have to be told in the instructions that they have to find those elements. So what the intermediate appellate court is saying was, look, this should have been brought under A2, and the facts support A2, but it wasn't brought that way. But the state Supreme Court and the instructions must have told the jury, you must find the elements of force in order to convict under A2. Okay? And now a case that that I hope in reading it let me just ask it this way. Let me ask you a question. If you were going to sum up your reaction to this case in one word, you're only allowed one word now, so if you give me more than one word, I'm going to be a very unhappy candidate. In one word, what would your word be?
Fury.
I'm sorry?
Absolute. No. Fury. Fury.
I should have known that Ms. Harper could not limit herself. Fury, okay? Is that one word?
Yeah, it is.
It's got at least have a hyphen in it.
Nope.
Alright.
One word.
Alright, okay. Anything else? I'm sorry?
Disgust.
Disgust. Anything else? Unjust. Anyone else? So is that? Yeah. Oh, that's not a hand. Extortion. That's not a reaction to the case.
Oh, I thought we were talking.
Unless you felt like somehow you were extorted.
Asshole.
I'm sorry?
Asshole.
Asshole. Thanks. I'll give you mine. Disbelief. Because sometimes you just shake your head and say, what were they thinking? Disbelief is mine. All right. Millenarch had been convicted of rape and attempted rape of a 14-year-old girl. And the argument is that he coerced her into repeated acts of sexual intercourse. How did he allegedly, by the prosecution argue he coerced her?
He said he would send her back to juvie.
I'm sorry?
Send her back to the juvenile detention center.
Detention facility, you said? The envelope. Detention is the word of the day. He was going to send her back to a juvenile detention facility. Now, this is not in your excerpt, but let me give you a little bit of background. The 14-year-old girl, the complainant, had been living with her brother and his family. So her brother and his family, a few houses away in the same block as Millenarch. She admitted she had been stealing from her brother and his family, and she said she lost a diamond ring belonging to her sister-in-law, her brother's wife. Okay? This resulted in her being committed to the detention facility. Right? Her brother was fed up, not going to put up with this anymore in my home, etc. At that point, after she had been committed to this facility in the first place, Millenarch steps forward, and he offers to let her come live with him. And the complainant's father agrees to the offer. And then at a hearing in juvenile court, this arrangement is approved by the juvenile court judge. Okay, everyone got the sequence? She goes to juvenile because of what's been going on at her brother's house. Millenarch, seemingly at this point, a good guy, willing to try to help her out, steps in, steps up, allows it. Okay? So then, what happened in May and June of 1980?
She chose to engage in the sexual acts with him.
She chose. That's an interesting choice of terms on your part.
Well, it's what the court said. I guess.
It's what the court said, and you saw the reaction to that around the room. In any event, she did.
Yes.
She engaged in sexual intercourse with him, and he, under the threat that he would take her back to the detention home if she did not comply. Under this threat, he first, a couple of times, unsuccessfully attempts to have intercourse with her, and then late in June of 1981, he completes an act of intercourse with this 14-year-old girl. So how does Pennsylvania law define rape at this time? Johnson.
Are you talking about section 3121
What
of the
does it
crime
say?
code? Okay. Person engages in sexual intercourse with another person, not his spouse, one by forcible compulsion or by threat.
What did you say before you got forcible compulsion with a person?
The person not his spouse.
Not his spouse. That, folks, is your classic marital exemption. That kind of language, if you see it in a statute, means, and Pennsylvania had it at this time, that a man could not be convicted of raping his wife. Okay? There it is. There is your classic marital exemption. Okay? And Pennsylvania did not remove its marital exemption until 1995. Okay? Seems perhaps to you guys like a long time ago, maybe some cases before you were born, but that's not that long ago. This marital exemption was in Pennsylvania's criminal law a very, very recent. Okay? So with forcible compulsion or threat of forcible compulsion. And the compulsion has to be that which would prevent resistance by a person of reasonable resolution. Okay? So how far does threat go? Threat is what the prosecution is alleging prevented resistance. How far does threat go under the statute as the courts have interpreted in Pennsylvania?
I guess a threat of physical force and psychological.
And psychological what?
Duress.
Duress. Right? So threat includes both physical force, that present here, a threat of physical force in Millenarch. The prosecution alleging that Millenarch in any way threatened that he would hit or injure physically the complainant.
No.
No. So if it was limited to that, the prosecution wouldn't have a case. Might be able to bring a statutory rape charge, but not under this statute. But it includes both physical force and psychological duress. And that's where the opening is for the prosecution, that Millenarch put the complainant under psychological duress with this threat: I will send you back to juvie, the juvenile detention facility, unless you have sex with me. Ms. Clemens.
Could the prosecution try and make an argument for physical force if she had been bullied in juvie, or there was a risk that she would be, or he knew there was a risk?
I want to hold off on that question for a few minutes, if you don't mind, because I'm gonna turn that question back on you in a weird sort of way. But let me put that off for now. Psychological duress. So, if somebody threatened to send you back to juvenile detention, would that create a duress for you? Now, some people might be able to say, I think you're bluffing. I would rather go back to juvenile detention than have sex with you, you creep, you predator. Some people might say that and be able to deal with that duress. But it is duress. It is like, wow, what a choice you're putting me to. And I feel pressured. I feel like I don't have a choice. And that's the prosecution's theory. What does the Pennsylvania Supreme Court say about this?
Well, they don't think that it was psychological duress.
Why not?
They said that she found the prospect of being returned repugnant, but
You found it what?
they found that she found it repugnant,
But?
but she was still given a choice.
So, as long as you are given a choice, it's not duress. What if he had said, I will, if you don't have sex with me, if you don't engage in intercourse with me, I will kill your brother. Now, this is the brother she stole from, so maybe she's not all that fond of him. But let's assume she's not that negatively disposed towards him.
I think that would still qualify as duress.
That would. What? What's the difference? Doesn't she still have a choice?
I mean, it.
Or couldn't she say, oh, go ahead and kill him?
But
But is it? But it's different. You're absolutely right. Your instinct was it's different. Why is it different?
It's not affecting her. It wouldn't. I mean, he's threatening to harm her brother, not her.
Still putting her under duress, isn't it? I mean, that would be a reason why it might not be physical force, unless the physical force part was the complainant or others. Let's say it didn't say or others. So we're not going to have the physical force part. Why is that threat, under the court's approach at least, different, and why would it create psychological duress, whereas the threat to send her back to juvenile detention did not?
Because that threat is closer to like imminent danger that courts think traditional.
That's not, that is a potential reason, but it's not really true, because it's not right that minute, right? She still has time, potentially, to, call the police before he can go kill her brother. So I don't know if it's immediate enough. There's another reason.
It's threatening actual physical harm.
No, I want to keep it on psychological duress. Again, because it's not physical harm to her. If the statute says harm to others, yes, you can go to the physical force part. But I'm going to keep it on psychological duress. What's different about that threat, Mr. Camden?
To me, the only difference is that the institution, going to a detention facility, is like 1 degree of abstraction more than killing your brother.
What is, if you are representing Millen Orange, and how many of you want that job? Well, I'm sorry. I apologize. If you're representing Millen Orange, what are you going to say is disturbing but true about his threat to send her back to the juvenile detention facility?
The emotional makeup of the victim is like irrelevant, but it's like an objective.
No, it's subjective, but
It's within his right to send her back?
there you go. Excellent. Right? He's doing that, putting her to that choice, if it's a choice. He didn't have to take her in the first place. He can he legally kill her brother? No. But he can legally send her back to the detention facility. So the other thing, the other side of that choice, in the case of sending her back to the facility, is a valid thing. He can do it, and she can accept it. He can't threaten her brother. So that would put her under duress in a different way. So the court says, look, he is putting her to a lawful choice. And the court says, where the victim can make a deliberate choice to avoid the encounter, even though the alternative may be an undesirable one. Right? So the fact that it's undesirable as opposed to illegal makes all the difference in the world. Should it? That's a different question. As the dissent says, the dissent is very vigorous, has some hypos. About, say a police officer threatens to imprison a female motorist at night, a male judge abusing power. All of those, the majority would distinguish as illegal threats, like the killing the brother. The dissent says, has civilization fallen so far, have our values become so distorted in this place as to leave a 14-year-old child without protection when she is forced to make such an awful choice, in quotes?
I was just going to, just generic question. He was still found guilty on other counts, wasn't he? Because it says he was found guilty of all counts, and I don't have the list of counts. The only ones that were reversed were
the rape and attempted rape.
Yeah, and then what were the other counts that he was convicted of?
Deviant
You
sex.
just got yourself some homework. I want you to look up the full case and report back to us on Monday. What else was he convicted of?
Sure.
Okay? All right? Now, I put off Ms. Clemens' question about what if she'd been subjected to bullying at the detention facility. Because I want to talk to you about a case called Yates versus Commonwealth. And the citation, if you want to look this up, but I warn you, if you look it up, you are not going to be happy. So, a word to the wise. But the citation for it is 430 Southwest 2nd, 883, Kentucky, 2014. 430 Southwest 2nd, 883, 2014. Kentucky Supreme Court dealt with these facts. They will sound vaguely familiar, very similar to Millen Orange. Sally was a 14-year-old high school freshman in 2010. She lived with her mother, her 2 brothers, and her stepfather the defendant Yates. Okay? She was dating an 18-year-old upperclassman named Austin. Yates discovered her relationship with Austin. She's 14, Austin is 18. He confronts Sally about having this older boyfriend, and he told Sally that her mother would not approve of this relationship with the older boy, and threatened to tell her mother about the relationship. He then said that if he did tell her mother about the relationship, her boyfriend would go to jail for being in a relationship with her because she was a minor. This confrontation went on for several hours, and then Appellant escalated his threats as the night went on. He eventually told Sally that Austin would go to jail and be hurt by other inmates if they found out he had been with a minor. At some time during the confrontation, Yates told Sally that if she would do something sexual with him, he would, in exchange, not tell her mother about the relationship with Austin. Okay? After Appellant made his offer several times during the evening, if you can call it an offer, she thought about it. She had growing concern for her boyfriend and decided to go along with Yates. At trial, she also said that she said yes. She only had sex with him to protect the boyfriend. She also testified that she had refused sexual advances from Yates on previous occasions. But this time was different because she believed that Yates would in fact send Austin to jail, and that Austin would be hurt because of their relationship. Okay? Yates was indicted on 1 count of first-degree rape, 1 count of first-degree sexual abuse, 1 count of unlawful transaction with a minor, and 1 count of being a persistent felony offender. It should surprise none of you, from what I've just described, that Yates had prior felonies such that he could be charged as a persistent felony offender. At trial, he was convicted of 1 count of first-degree rape and 1 count of first-degree sexual abuse. He was sentenced to 21 years in jail. Okay? Kentucky Supreme Court says, look, forcible compulsion can be shown in one of 2 broad ways. And I want you to look at Chapter 510 as we go through this: an act of physical force or a threat of physical force. Right? An act of force or a threat of force. Okay? And Yates says forcible compulsion was not meant because it was voluntary. It was voluntary. There was no threat. Yates says his statements to the victims did not amount to a threat of physical force under the statute because he did not threaten to hurt the victim's boyfriend himself, and any threat of harm was not immediate enough to be a threat within the definitional scope of forcible compulsion. Okay? What result?
Not guilty.
And I hope you can see why I put Office Clemens' question to bring up Yates, because you had this idea of what if there's a threat, and the threat is of, you think somebody, in this case not the complainant, but the complainant's boyfriend, will be harmed in that system, whether it's in juvenile detention or in jail, as Yates threatened Austin. Okay? What do you think the Kentucky Supreme Court said? For those of you who were appalled by the Pennsylvania Supreme Court. Well,
Probably the same thing that the
I'm sorry?
Probably the same thing that Pennsylvania said. because,
Why? What in the Kentucky statute would have been a barrier to this conviction?
He didn't give a threat of force.
What threat of force?
Had to be an act of force or a threat of force that did not.
What in the definition of threat of force? There was not an act of force, but what in the definition of threat of force was not met? What do you have to threaten in order for it to be forcible compulsion via the threat part?
Fear of immediate death.
Immediate was the key. The court said it would have required a series of steps, right? First, he would have had to tell the mother. Then the mother would have had to report to the police. Then Austin would have had been sent to jail, and there would have had to been violence done to Austin while he's in jail. That is not immediate. And so it is not a threat of force or of harm, and therefore Yates could not be convicted under the rape statute. If you look at this is in the definition of forcible compulsion. All the definitions in 510 are in 510.010, and forcible compulsion, the immediacy issue, is included in 510.010 subsection 2.
Are there any states that deal with this options of choice well? I mean,
I have not seen any cases that go the other way.
so this is pretty standard.
Well, and again, this is a little different logic than the Pennsylvania court used, right? The Pennsylvania court said he was lawfully entitled to put her to this choice, and therefore she still had a choice. It wasn't duress. Here, the Kentucky Supreme Court sort of focused on the immediacy issue, that the harm that was being threatened might be of harm, but it was not immediate. So this is an area, I would suggest to you, in which there is room for some statutory exploration of reform that might allow maybe a lesser offense, maybe crimes that are specific to the fact that juveniles are more susceptible to threats and don't have the maturity or the knowledge that they can say no, and that there may be steps available to them to report the threatener. I mean, that may be an area in which there needs to be legislative attention in states across the country, perhaps in a uniform way.
How to answer this?
I would turn it around slightly, and I would say that I think even adults, even 30-year-olds, are susceptible to the coercive power, may feel trapped, may feel helpless in these situations. And if that's true, then by even more obvious that a minor, a 14-year-old, or someone in that age range, would have no sense of being empowered to deal with the situation. So I guess I don't want to characterize it in a way that would suggest somehow that we would let the person who threatens the 30-year-old, that we would think that that's not a problem. But I would say it's even more of a problem with the 14-year-old. Ms. Clements, did I see your hand?
Well, I was going to see if you could differentiate between this situation where he's threatening, where he's saying there's the possibility of physical harm when this person rightfully goes to jail for doing something that's illegal. That's not you.
You think
Versus
that's what Yates said to this 14-year-old girl?
No.
It might happen. It's a possibility.
I don't think he said that's what happened, but I think like that's your defense, or that's an argument you can make.
I think what he said is he's gonna get raped. He's gonna get assaulted. It's gonna be, and it will happen when he's sent to prison for being involved with him. And it's your fault because you got involved with him. So he worked guilt into the threat. So,
So then if you're talking, if you were talking to her, like if it were the case that we just went through, and they're saying, we know there's a history of you being abused in this detention center, and I will send you back, and you will be abused again. Like, there's no differentiation between that and this.
If I'm writing the statute, I write the statute so that it covers both those cases. Because those are situations, certainly in the case of a minor, maybe I give an affirmative defense in the case of an adult, where an adult is the complainant, is the victim. But I cover both those cases equally. That's me. That's just me. All right. Here's the deal. I have your box assignments. They are in alphabetical order by the first person alphabetically on each team. That's the order they're in. So the easiest thing to do is have that person come forward. So if you were the first person alphabetically for your team, come forward and get your box assignments. And they're in order by team.